Hello, I'm Peter Afrasiabi, a partner at 1LP and host of the Curious Lawyer series. The Curious Lawyer is a sort of fun, interesting walk down different areas of law that you may not be familiar with, areas of law that intersect with society and with all of our practices, but are out off the beaten path. It's not what you do every day, and it's a little different. And it's designed to be fun and interesting, entertainment and educational at the same time, and to really arm you with some fascinating legal information about areas of law you may not be familiar with. So we've done space law, where we've explored who owns the moon, who owns asteroids, how do companies that are getting ready to start mining asteroids monetize the minerals they may find, what happens if space junk falls to Earth, who's responsible, and all those fun, fascinating questions. We've looked at dog law, where we have discussed and assessed how the myriad different legal regimes from state and federal law even intersect with our ownership and support and love for our feline and canine friends. And we've looked even at presidential pardon law to have a detailed discussion about the Constitution and the case law that revolves around the ability of the president to issue pardons, the scope of them, and even the issue of self-pardoning. Today, we have celebrity and paparazzi law. Celebrity and paparazzi law, of course, is going to address fascinating issues about celebrity and celebrity culture and how celebrities create, protect, and monetize their brands. But we're also going to look at the other side of the coin, which is the paparazzi, the people who take the photos that society so demands. And so, if we look at our first slide, what we're looking at really is a set of issues in the modern celebrity era. And some of the most popular websites in the world really revolve around celebrity-based content. There are myriad websites that are devoted to celebrity culture. Our rock stars, our actors and actresses, our pop stars, all sorts of celebrities, sports and other entertainment folks. And many of these websites are far more popular than massive news sites. It's somewhat surprising to learn that fact for people. One study has even shown that the top 3 content-driven websites in the world, really, in terms of what people are demanding, involve pornography, celebrity content, and reference searches. This is even more than people looking for sports or shopping-related data. So that just gives you a sense of how massive the demand is for celebrity content. That, of course, means if there's a massive demand for celebrity content, and specifically we're really talking about celebrity photos and videos, right? Because the medium by which we as a society absorb and consume celebrity culture is historically television, and before that even radio, but television and print journalism such as People magazine, and in the last 20 years certainly the internet, where we can see massive amounts of high-resolution photographs of our favorite celebrities or videos of them in public doing whatever it is they may be doing in public. This, though, in turn, because of the massive demand and access to celebrity content, has driven up the value of celebrity endorsements, which means this insatiable appetite for celebrity content translates to massive issues within the legal system about how one gathers the content, how one regulates the gathering of the content, and what it means to really ultimately be the possessor of celebrity content. And so for us as lawyers, this manifests itself in a couple of ways. One, you may have celebrity clients who have a brand that they want to monetize, who want to exploit photos of themselves. You may have budding potential celebrity clients, and these can be people in the traditional outlets such as television, film, music, but there's a whole range of new celebrities, so to speak, such as your Instagram stars and your YouTube stars who have come to fame through those new internet channels and who have genuine celebrity brand value that they can monetize. Now, you may have clients who are not celebrity clients or even the new celebrity clients, but they're businesses that want to sell their cereal or sell their shampoo, and they'd like to use a celebrity name, likeness, evoke the celebrity perhaps to sell that brand, and that triggers the issues that we'll talk about today. So understanding celebrity-based law really is very important to the general practice. But the other side of this picture, the other half of the coin, so to speak, involves the paparazzi. And The paparazzi, of course, are the ones who, by and large, get the very content that we as a society, as a body politic, are so consuming. And so there is this symbiotic relationship that's fraught and tense at times between celebrities on the one hand and the paparazzi on the other hand. And it bubbles to the surface at times with immense tension, such as you may all recall in the late 1990s when Princess Diana in her Mercedes in France crashed and she died, apparently as being chased by paparazzi. And that bubbled to the surface the sort of tension between the celebrities who don't want to be pursued by the paparazzi and the paparazzi who are pursuing the celebrities to get the photographs because that's what the public demands. That bubbles to the surface every once in a while and then it simmers down. But the two really live in this fraught symbiotic relationship because ultimately it is the paparazzi that get the photos that keep the celebrities in the public eye so much that helps build their brand and their endorsement value. And so, as you see on our slide, this uneasy alliance between celebrities and the paparazzi and then our social demand for the content really is mediated by three principal bodies of law that we are going to look at as we discuss celebrities and paparazzi law. And those bodies of law that sort of intersect with celebrities and paparazzi are copyright law, right of publicity law, and the First Amendment that sort of stands behind all of this and is so foundational in the United States to what may and may not be done in public vis-a-vis collecting celebrity images. When we are addressing copyright law, what we are looking at really is who owns the photos of these celebrities taken in public, who possesses them, who can exploit them, and how can they exploit them, and what are the limits on how they can exploit them. And we're also going to look at very, very current issues in terms of social media and the social media boomerang that has occurred for some celebrities when they have built their own brand on their social media websites and they have used photos of themselves, but which photos they don't own the rights to, and that creates fascinating issues. The other side of the coin we're going to look at, of course, involves right of publicity, and this gets more to the celebrity side vis-a-vis the paparazzi side, which tends to be the copyright side. And as we look at the celebrity side of our equation, we're looking more really at the law known as right of publicity law, and it's the set of laws built around the ability of celebrities, and anyone actually, not just celebrities, but today we're talking about celebrities, but it's the celebrities' ability to monetize their name, their image, their likeness, their persona, so to speak. And so in looking at this, we're going to talk about things such as Bette Midler, the famous Cheers case, dead celebrities even, and a whole range of fascinating celebrity cases we will get at. So, as a primer, as we get into paparazzi law, let's turn to our next slide and we're going to just do a quick overview of copyright law so you understand the fundamentals that are driving photographs in particular and video content of celebrities in terms of the legal regime. And so the primer is as follows. Copyright is a creature of federal law. It's exclusively the province of federal law, of Congress that is, as given to it by the Constitution. And as the Copyright Code has been written, one may possess a copyright in works that they create if it is an original work of expression and it's fixed in a tangible medium. Let's talk about both of those. The first one on the next slide we're going to talk about is originality. Now, originality does not mean, as some of you may think, that it must be breathtakingly novel or new. That's the province really of patent law, where when you have a breakthrough, novel, fascinating invention, you go get a patent. Copyright law doesn't have the same unique novelty component to it. Originality really just means that it's original to the source, and it's a low threshold. There's a minimal amount of creativity that's required. And as the Supreme Court has said, you can see there in the site, the minimum threshold is extremely low. And that's the case of Feist from the United States Supreme Court in 1991. And that holding really was just restating long-standing copyright law that this is a low threshold. At root, the reason it's a low threshold in terms of the amount of creativity that's required is that courts don't want to get embroiled in the merits of artistic quality disputes. when it comes to the quantum of creativity that a photographer may use, an artist may use, a painter may use, courts don't want to be embroiled in a dispute as to whether a particular painter, for example, had enough creativity in making a painting. For example, Van Gogh is very, very creative, and yes, that would count, but some painting that maybe looks far less creative and it's just some lines splashed on a canvas, courts don't want to be embroiled in a dispute as to whether that, for example, maybe doesn't qualify for copyright. And it does because the standard is low. We can see the reason for this traces back to a decision from the turn of the last century. In this case, it's called Bleistein versus Donaldston, and it's from the United States Supreme Court. You can see it's reported there at 188 U.S. 239. And this is a quote from Justice Holmes authoring the opinion in the case at page 251, where Justice Holmes wrote, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge." That's the root philosophy that underlies the idea of originality and why courts don't embroil themselves in the disputes. So, if right now while you're listening to this, you're doodling and creating a fun little design on your paper, lo and behold, you've earned a copyright as of today. And that's because, as we go to the next slide, we see the second requirement, and that is fixation. And fixation, again, is a very low threshold. What it means is it must simply be fixed, made, that is, in a tangible medium. So your pen on the paper right now, that's a tangible medium. Typing on a keyboard and creating the words in the operating system and the RAM of the computer, that's a tangible medium. A paintbrush to a canvas is a tangible medium. So really the only requirement is that it be a permanent reduction to some sort of form. But beware, skywriting doesn't count. So if you've come up with the greatest poem in the world that you think is going to make you a millionaire because it should be copyrighted, and it's an ode to your loved one, and you pay a skywriting company to paint it into the sky with the skywriting smoke that they use when those airplanes are up in the sky doing that, you will have dedicated your poem to the public and shown it, but you will not have recorded it to permanent form. And so someone else may go do that before you. So record it to permanent form. This gets us to the next slide. What things fall within the realm of copyright? And it covers a whole range of different sorts of creations that one may have. Books, novels, short stories, pamphlets, other writings, music, film, artwork, software and source code. Even architectural works have some protections under the Copyright Act in the last 30, 40 years. Clothing designs, which really in the last 5 years, in sort of 2016 and on, or the last 2, 3 years really, but since around 2016, clothing designs have had life breathed into them by the United States Supreme Court, and those have been found to have more copyright protection than perhaps was thought in prior years. Pantomimes, choreographs, plays, etc. And of course, for purposes today, celebrity photographs. And there we have a photograph which is of Michelangelo's David from the Renaissance. And I suppose if the Renaissance, as historians say, really began the modern era where we are today, it could be that Michelangelo's sculpture of David was the first celebrity creation, albeit of a biblical figure, but for the modern era. And perhaps David, since the Renaissance, he may have been the first celebrity that was massively appreciated, watched, copied before photographs by pencil, upon the advent of photographs by photographs. And in any event, there could be a celebrity culture that exists around David. But we're not going to focus on David. We're going to go to our celebrities today in the United States and the modern world. And so let's fast forward from that to the really modern era of copyright. And that brings us to the next slide. And this is really what could be considered, in some sense, the first celebrity photograph case in American history. And this is from the late 1800s. The case is Burrough-Giles versus Cerrone, reported at 111 U.S. 53 from 1884. And it involves, as you can see here on the slide, a photograph of Oscar Wilde, the famed writer and poet. And so basically here's what happened. Burrough-Giles was a business. It was a company that was in the business of selling photographs and other materials. And it went out and created lithographs, that is copies, of this photograph of Oscar Wilde, which had become a popular photo of Oscar Wilde at the time. And it sold them and it made money. It was in the business of monetizing content, one of the sort of earliest versions in many respects of perhaps what People magazine does by monetizing celebrity content also. But in any event, it did this, and the photographer, a man by the name of Cerrone, was not happy. And so, as we do today, we did back then, Cerrone filed a federal court lawsuit for copyright infringement, claiming, I took that photo, I own the copyright to that photo, you don't have a license from me, you don't have consent, you can't just take my photograph and reproduce it and make money from it. Now, the defense at the time of the company was that, well, it's just a photograph. You had Oscar Wilde sit down, you picked up your camera, you snapped the photo. It's not original, it's no big deal. There's no effort or creativity there that really justifies copyright protection. And this was sort of an important first case that kind of started getting to the issue that you saw the quote on from Justice Holmes earlier, where courts had to grapple with, does this meet the minimum level of originality? And the court held no, photographs are the types of works subject to the Copyright Act, which of course photography was a new medium at the time of the 1880s or so. It had been around for a few decades obviously, but it was still new. And the court said, nope, photography is within the realm of copyright just as sort of maps and writings are. And that Cerrone's efforts here were legitimate efforts, and that was his authorship and his original creative expression, even if it's just kind of the selection of the pose, the lighting, and where he wanted him to sit. And so the result of this case, if we look at it through the prism of sort of celebrity culture, is that that's a celebrity photo, and the copyright to that celebrity photo belonged to the photographer. And what that meant was there was really a new asset in existence for monetization, and this set up the stage really for what has been now a century-plus battle between those who want to own the copyrights to celebrity photos and those who want to monetize them without licensing them. Then it was lithographs. Today we see the same battles being played out in the internet era in terms of modern websites and whether they need to pay license fees or not. So this was sort of one bookend to the celebrity copyright world from the 1800s. And I want to momentarily now fast forward to today, which is sort of the other bookend. And let's take a look at the most modern sort of technology we're now dealing with in the Internet 2.0 or even 3.0 world, which is social media. And this brings us to the next question, which was alluded to in the beginning of this program, and that is, what happens when a celebrity takes another's photograph of himself and reproduces it on his social media site? This creates a collision between copyright and social media, and it's the same type of collision that we saw between Cerrone and the Burrough Giles company in that photograph of Oscar Wilde, only now it's between the celebrity and the photographer. And the way we can explore this is through a hypothetical. And let's just imagine for a second that Oscar Wilde were alive today, and that photograph was taken just last week, and Oscar Wilde, like many celebrities today, has an Instagram page and a Facebook page and a YouTube page. And those pages enable Oscar Wilde or a celebrity to really self-advertise and self-promote their brand and themselves directly to their fans in a way that before the internet they really didn't have the ability to do. If you think of sort of the pre-social media, pre-internet age, Mel Gibson or Julia Roberts back in the 1980s or 90s may have had a massive fan base, but they didn't have a direct pipeline into that fan base. Their connection to their fan base was often mediated by the magazines that published interviews and articles of them and the television programs that did the same. Now there's a direct pipeline to their fans and audience. And so let's imagine that Oscar Wilde had that great photograph of himself taken, and he liked the photograph and he decided, hey, I want to show it to all my fans to help build my brand. And he took a copy of that photograph and uploaded it to his social media website pages. Thinking, of course, it's me. I'm the subject of the photo. Of course I can use the photo. Turns out under copyright law, no, you cannot. The subject of the photo is not the author of the photo. And that's sort of the general rule almost all the time. And so what that means is that Oscar Wilde would need to get clearances the same way you or I would need to get clearances before we reproduced and publicly distributed that photograph on the internet to the world. And this sort of gets at this fascinating collision then between copyright and social media and what's occurring really today. And it shows the boomerang effect that can happen with the ease of technology and with copyright law and celebrities perceiving that photos of themselves belong to them. So let's now move to the next question, which is, how far is too far with celebrity images? And this kind of starts getting at one of the issues we look at, which is, when may or may not one take a photograph of a celebrity and how do you use it? Well, the First Amendment allows broad rights to paparazzi photographers, to you with your cell phone if you want, to, when you see a celebrity in public, snap a photograph of them. And so here we have an example of a photograph, and it turns out, yes, that photograph was taken by a client of mine, and I have permission to use it here in this presentation, so this is not an infringement of that photo, even though it would actually be educational fair use, but that's for another presentation you can watch of ours. In any event, it's a photograph of Katy Perry that was snapped in public. There you can see her smoking a cigarette, and this was sort of the height of her fame before she was getting ready to go on a world tour, and there was a massive demand for that photograph. And so the photograph was taken, and then it was licensed to a whole bunch of media outlets for their use in celebrity reporting. And the First Amendment perfectly allows that. And so that means the paparazzi or the photographer that snapped the photo in public, they have the right to do so, and they have the right to license that photo, which they own, to news media outlets who are showing the photo and reporting on Katy Perry. But there are limits to how far one can go with a photo. So let's do a hypothetical. Since that photo happened to involve Katy Perry smoking, as you can see, imagine that the Marlboro company, Philip Morris and Marlboro, or whoever owns Marlboro, had come along and said to the owner of the photograph, hey, I want to use that photograph to help pitch my cigarettes. That would be an infringement then of Katy Perry's right of publicity, because she has the right to control her persona in terms of how she is used to help sell products. And so that's a perfect example of the line between copyright and right of publicity for celebrities in terms of how far one can go in terms of using and exploiting a photograph taken of a celebrity in public. And the last picture there you can see is actually a real world example that I pulled to show you of a famous actress, Katherine Heigl, who had been shopping at a store and coming out of the store using the bags. That's a fair shot of her to take and use, but it's not fair for the store to put that picture up of her to help promote their store, their brand, in terms of a place for shopping. And that would be an example of going too far if it indeed implies or expressly states that she is lending her name and her persona to that store to help sell that store. Very easy to go too far, as you can see in the modern era. And this now is something that pops up more and more, you find, for very, very small businesses, because given the ubiquitous nature of cameras on cell phones, more and more celebrity photographs are being snapped every day. They're being caught and seen, for example, in all manner of businesses, many of which are just small local businesses. And you may be representing those companies who suddenly want to take advantage of that fact to monetize it. And one has to be very, very careful that you monetize it accurately and fairly without crossing into a false endorsement from the celebrity, which will boomerang on your client with right of publicity claims. So, as you see on the next slide, the root issue we've shown here, and we can see, is that technology and the public's appetite really has spawned a celebrity photo age. And this has sort of created the industry and the desire to have these photos and capture the photos that we all want. And it traces really directly from that first photograph of Oscar Wilde that a savvy business had figured out how to monetize with lithographs, all the way up to the modern era of People and these other magazines that have built an entire business around celebrity culture and photographs of celebrities. This requires, however, us to get to the root question of paparazzis, because all of these celebrity photographs are indeed taken by someone, and by and large, they're taken by an industry of photographers that have come to be known as paparazzi, and this is the other side of the coin. And so this is going to get us to paparazzis. As you can see on the next slide, we're now going to talk about really the birth of paparazzi law. And this gets at privacy rights, public spaces, trespass, and really the First Amendment. And you can see there a photograph, and for those history buffs watching this presentation, you may recognize who it is. It's John F. Kennedy Jr. on his bike, and behind him is his mother. And the man in the hat you can see there is a Secret Service agent desperately trying to keep up with young JFK Jr. as he rides his bike in the park. And that's a photograph snapped by a photographer, which really gets us to the first case in American history dealing with what's known as the paparazzi. This brings us to the central question, what is a paparazzi? And the history of the definition is actually quite fascinating, because the word has certainly become a word that we as a society use, and it's a word that's used as a very specific word in the case law even, and so it's taken on and it's imbued with legal terminology. But to get at the history of the word is actually a fascinating story. It starts with Fellini's movie, La Dolce Vita, and in that movie there's a character, and the character's name is Paparazzo. That's just his surname. And it turns out Fellini's character in the film, Paparazzo, was actually inspired by a famous Italian photojournalist, Tazio Secchiaroli. And Mr. Secchiaroli founded the Rome Press Photo Agency, and he was really famed at the time for his exploits in getting celebrity photos in Rome and in Italy. And so in the film, there's this photojournalist getting photographs, and his name is Paparazzo. So Paparazzo is a news photographer. And what has happened, as we will now see as we go to the next slide, is that that word paparazzo, which was just a name, it's a surname, has become known in the plural as paparazzi, and it's become used to denote and define an entire class of people engaged in a trade. So this brings us to the next slide and the case involving that photograph we were looking at in terms of JFK Jr. So what exactly is a paparazzi? This came up in the case of Ronald Gaea versus the Kennedy Onassis family. And the case is from the early 1970s, and Ronald Gaea was a photojournalist in New York. And there's this big legal brouhaha, which we're going to talk about. But in that case, he told the court, "I am the first American paparazzo," riffing off of the character from La Dolce Vita, of course. And the court adopted and accepted his claim to be an American version of paparazzo, and hence the word paparazzi was born to no longer define a person as a surname, but actually to define a class of people engaged in an activity. And it's really actually fascinating, because when you look in the decision, the trial court decisions before this case worked its way up to the Second Circuit, talk about how the word had already taken on significant meaning in sort of social discourse. And they noted that Newsweek magazine had defined paparazzo as an annoying bug. And they also indicated that paparazzo is literally a kind of annoying insect, perhaps roughly equivalent to the English word gadfly. That was the word of another district court in the case. And so what happened in this case is that the court really looked at what it is that Mr. Gaea is doing and really compared him to, other sorts of folks engaged in news gathering. And you can see here a quote, which is really a very important quote, because it really sets the stage for bedrock assumptions about paparazzi in society and the negative connotation that has attached to them. And so here you see the court saying, "We emphasize that the trial court did not relate to a news photographer, a news reporter, or a photojournalist endeavoring to get a story about a woman and her two children who were, and in our opinion still are, the object of legitimate photo interest. The record establishes at least these differences between the behavior of other photographers and reporters and the attack of the paparazzo in this case." And so the court really drew a distinction between, while recognizing that Mrs. Kennedy Onassis was a public figure and it was a matter of public interest to know what was going on in her life, for example, there was a line between what the court perceived as legitimate news gathering and just annoying harassment for the sake of, being a gadfly, so to speak, and a pest. And what this does is sets the stage really in the case law and in sort of the legal jurisprudence for the idea that definitionally paparazzi aren't really true news gatherers. They're not the Woodward and Bernsteins of the world, or they're not, photojournalists, out snapping photographs in war zones, for example, and they're more sort of pests doing something that the First Amendment allows them to do, but it's not really very important. That's the sort of idea that underlines this. Now, today, you fast forward 45, 50 odd years, they're still broadly understood with the same pesty connotation, but it's taken on the meaning that really it refers to freelance photographers who pursue celebrities for photos. So, what is this case about JFK Jr. and his mom, Mrs. Kennedy Onassis, really about? Let's get at it. On the next slide, you can see what's going on and why the court was frustrated with Gaeta, who took the mantle of paparazzo for himself proudly. Here's what was going on. Gaeta took pictures of John Kennedy Jr. riding his bicycle in Central Park across the way from his home. He jumped out into the boy's path, causing the Secret Service agents to be concerned for JFK Jr.'s safety. The agent's reaction and interrogation of Gaeta then led to his arrest, actually, by the agents. On other occasions, Gaeta was out there interrupting Caroline Kennedy at her tennis camp. He was invading their private schools. Mrs. Onassis was swimming one day in a lake, and he came too close in a boat to try to get a picture of her. He would, pose around areas where she was in public, such as at theaters and other places. And he even, quote, followed a practice of bribing apartment house, restaurant, and nightclub doormen, as well as romancing a family servant to keep him advised of the movements of the family. So that's the backstory to what was going on, which led Gaeta to have this interaction one day in Central Park with the Secret Service agents who detained him. They had him arrested. The case against him was eventually dismissed, but he filed counterclaims saying he had the right to do everything he was doing, and that set up a legal battle in the federal courts. And this was really the first time that the federal court started grappling with the issue of how far can a paparazzi go in public to get celebrity photographs? And what are the limits on this broad First Amendment right that does exist, but what sort of limits exist on that right in terms of state law regulations such as harassment, endangering people, and the like. And as a fascinating aside, I'll tell you, if you do a Westlaw federal database search, for example, for the word paparazzo, it actually confirms that the very first time this word actually pops up in American jurisprudence, in the federal database at least, is in this case. And so this really is the birth of paparazzi law in America. So what happened, as you can see on the next slide, is an injunction was issued against him, ordering him to stay a certain distance away, et cetera, et cetera. And he challenged the injunction, saying, nope, I have a First Amendment right to do this, she's in public. And the court started from the premise that absolutely she was a matter of public interest, she's a public figure, and she was subject to full news coverage. But the court said, nonetheless, this guy went beyond the reasonable bounds of news gathering. It noted, as you're looking at this, that there's a de minimis public importance of her daily activities. And his constant surveillance, the obtrusive nature of how he did it, his intruding presence, romancing family servants and bribing doormen and the like, really became inexcusable conduct and at some point put the kids in danger. And so the court ultimately held that state harassment claims and such torts can give rise to injunctions that limit how the news gathering occurs. And the First Amendment is not simply a blanket right to do whatever one wants. And so it is subject to these reasonable time, place, manner restrictions as embodied in state law, which can give rise to injunctions. And the injunction was upheld to limit Gaeta's activities. Now, it may be that Gaeta, who knows, if you look at this, with the prism, of 50 years benefit, perhaps he shouldn't have claimed the mantle of being a paparazzo, which had such a negative connotation, as you saw the way the court understood it. And perhaps he should have tried to position himself in the litigation more as a legitimate photojournalist. And were that the case, perhaps it wouldn't have resulted in such negative language in the opinion about the paparazzi industry. The root of it, however, is a balancing test. And this is sort of the effective test that exists today. And that is, you can see the court's quote in there in terms of how it dealt with the balancing test. And ultimately, it resolved that balancing test on the side of the injunction standing, especially since children were being endangered. The celebrity's children were being endangered by his behavior. So this gets to the next question we're going to look at on the next slide, which is, what laws do regulate paparazzi behavior? And this gets at free speech versus the public interest in celebrities and the privacy rights of individuals. Of course, we've seen the First Amendment already in the Onassis case, and while it does allow near free reign of photography in public, there are behavioral norms that can be imposed through state tort laws. But there are also other limits. For example, police crime scenes, even if it's a dead celebrity, who is a person of public interest more than just sort of a dead private individual, for whom, of course, there is no public interest particularly. But a police crime scene can be regulated by state law and not open to the public because of the important nature of police investigative work and gathering of the information and dissemination of the information in a way that doesn't impede the investigation, and such concerns. Those limits imposed by state law are legitimate. Government buildings can have security regulation occurring, and that can limit the right to take photographs inside those places, of the building or even of a celebrity in the building, such as no cameras in the courthouse type rules. There are general trespass harassment laws. We saw that, of course, the other side of the Onassis case, and this also gets at the California anti-paparazzi law, which we're going to talk about as an example of a state paparazzi law in the books. We also have laws dealing with zoom lenses, and we'll talk about those briefly, in terms of California, which prohibits zoom lenses being used to invade private spaces where there's a reasonable expectation of privacy. And we'll also look at a flip side New York case involving art and zoom lenses. Let's start, however, with, as you see on the next slide, California's anti-paparazzi laws, and which is really sort of the root being the no zoom lens law. This was enacted in 1998, and as you recall, I said in the beginning, in sort of right around that time, 97, 98, there was the massive outcry in terms of Princess Diana's death and the role of the paparazzi, and that's sort of part of the root of what was going on with this law, where laws were then enacted in California, which is obviously a heavy celebrity-focused state like New York, and so these laws get passed in those jurisdictions more. But California amends some laws and enacts them in 1998 to create the following standard, and this is the anti-paparazzi law. A person is liable for constructive invasion of privacy when the defendant attempts to capture in a manner that's offensive to a reasonable person any type of visual image, sound recording, or other physical impression of the plaintiff engaging in a personal or familial activity under circumstances in which the plaintiff had a reasonable expectation of privacy, when done through the use of a visual or auditory enhancing device, regardless of whether there is a physical trespass, if this image, sound recording, or other physical impression could not have been achieved without a trespass. So, as you can see, what the law was getting at was technology was evolving in terms of zoom lenses, and you more and more had folks being stationed on public property, but zoom lensing deep into private personal spaces. And because state common law on invasion of privacy and trespass law really dealt with the requirement of a physical trespass, there was a bit of a gap in the law, and this law was really enacted to fill that void, to say, hey, you don't get to use technological devices to be in a public place and zoom into a private place. Now, that law has been repeatedly modified really in the last 20 years and extended to impose criminal penalties in some circumstances. It's been extended in 2009, as you can see, to reach to ensnare those who may induce that behavior, such as media outlets or photo agencies that hire the paparazzi, for example, or websites and tabloid blogs, where they have actual knowledge that those photos were obtained in such circumstances. And so the growing trend, of course, is to protect the private space of a celebrity from intrusion by technology. And this will continue to evolve given new technologies. In 1998, it was really zoom lenses. Who could have imagined 20 years ago that there would be drones that one could hover into the backyard and photograph celebrities sunbathing at their pool, for example? And drones are certainly covered by this law, and it would be an absolute illegal act to hover a drone over, pick your celebrity's backyard and photograph them frolicking in their swimming pool. Other technologies that exist today are sort of laser beams that can be beamed to pick up perfect auditory sound, right? Stuff that's used by the FBI, the DEA, and folks, could also be used by private folks who possess a technology. And to do that into a private home would be another type of technology that would trip this law in terms of regulating and controlling how far paparazzi can go. The next case we're going to look at on the next slide involves Barbra Streisand, and this is sort of the backstop to the anti-paparazzi law, and it's an example of where the paparazzi are not going too far, so to speak, or where I should say a photojournalist or a photographer is not going too far when using a zoom lens for a distance. This is the Streisand Beach property case. And what it involved was a photographer in a helicopter who wasn't a traditional paparazzi. He wasn't trying to snap a photograph of Barbra Streisand in her backyard, and indeed he didn't. He just took a property of her massive bluffside estate, there you can see the photograph, which was not otherwise subject to photograph because of the way it was, the geography of the land is and the access to the beach. And he was doing this actually as part of a coastal records project that he was engaged in to document the entire California coastline, and he had a .org website set up. And this was really built at a sort of built around a conservation effort to understand the California coastline, accessibility, what was happening with it. Well, he got a photograph though of Barbra Streisand's property. And as I mentioned, it wasn't her on the property and it wasn't a shot into her house, but it was, as you can see, her home, her backyard, her property. So she wasn't happy. Barbra Streisand sued, claiming an invasion of privacy and also suing under the anti-paparazzi laws. The photographer didn't back down. He got a lawyer, he defended, and he actually filed an anti-slap motion saying he had every right to be engaged in this behavior. There was no invasion of privacy, and it turned out he won and her lawsuit was dismissed. The court held basically that occasional overflights are absolutely part of the ordinary incidents of life to which everyone is a part and expected. And she can't complain that there was an overflight near her property with a photograph taken for these types of purposes. It wasn't aiming to sort of get at her, so to speak. And the result actually was that the lawsuit was dismissed and Barbra Streisand was ordered to pay the defendant, the photographer named Edelman, his legal fees, which amounted to $155,000, filing the motion to get the case dismissed and the anti-slap motion. So that's a good example of how zoom lenses, while prohibited, are not prohibited if being used in other circumstances where there isn't a genuine invasion of privacy and it's not being done to harass a celebrity. And that's just a line to be well aware of. Let's take a flip side though, and let's go out to New York now, because we can see how this issue of zoom lenses is coming down differently in other jurisdictions. This is the Neighbors case, and the facts are as follows. And this case doesn't involve a celebrity, but the outcome probably wouldn't be any different if it was a celebrity. What happened is the following. An artist in New York by the name of Arnie Svensson went out and spent many years photographing New Yorkers just in their homes in New York. And he used telephoto lenses into the apartment buildings and the condo complexes just to snap photographs of people engaged in ordinary activities every day, going about their business. And you can see two of the photographs there. There's a woman bent over. It looks like she's cleaning the floor perhaps, or picking something up off the floor. There's another photograph of a guy taking a nap on a bench and his shirt's pulled up and you can see sort of his lower back right above the buttocks area exposed. And those photographs were taken really by Arnie Svensson over a period of time. And as we see on the next slide, what happened? Well, he held an art show. And the art show was built around this legitimate artistic idea to explore New Yorkers going about their business in their daily life, just in their homes and what it's like. And he holds an art show showing the photographs, and that was sort of the extent of the use of the photographs. But a magazine did in fact publish an article about this art show and what had happened. And in the magazine article, it showed a couple of the photographs. And that's what brought it to the attention of some of the subjects of the photograph, who were not amused to see themselves being portrayed in this art program in that way, even though they weren't recognizable from the front. They knew who they were from the back, obviously. And so they sued. And they sued under New York right of publicity law, invasion of privacy law. And the court held ultimately that, and you can see the published decision there if you want to go read it, but the bottom line holding of the court ultimately was that this was artistic in its endeavor. It was not an invasion of privacy, and it was not being used for any advertising or improper or commercial purposes, and instead really this amounted to legitimate artistic endeavors to which people are subject. And so zoom lens laws and invasion of privacy laws wouldn't engraft onto that. It's a pretty broad opinion, actually, that's drawn a lot of condemnation, and it's drawn, in fairness, a lot of interest on both sides of the decision, you know, those who believe it right, those who believe it wrong. But what it shows is this very important line between artistic use or fair use, for example, on the one hand, versus commercial exploitation of images, for example, on a cereal box or shampoo on the other, which wouldn't be permitted. And in that sense, the New York case is dealing with this sort of artistic fair use idea that sort of traverses privacy law and right of publicity law. The same way in the Streisand case, the California court was using the fact that this was, you know, for a public purpose of coastline documentation as part of a coastline, you know, wetlands environmental project. This now gets us, as we're moving along in this program, to right of publicity law, which is really the central body of law to the celebrities who have been subjected to these actions of the paparazzi. This brings us to the statutory right of publicity. The original derivation of what today is a sort of state-driven statute, positive codified law right, the original derivation was common law, coming from privacy law, the right to privacy. Really now, almost all states have codified a right of publicity statute, which belongs to not just celebrities, but also all people. Of course, our presentation today is focused on celebrities, so we will be continuing to talk about the right of publicity, traversing it through the prism of the celebrity. The root protection under these state statutes is to prohibit the unauthorized commercial use of one's identity, which varies by state as to exactly what aspects of identity are protected. The various aspects of one's identity that we can think about are things such as one's name, one's voice, one's likeness, a photo, picture, image of a person, you know, the literal likeness of them, and even the persona, which is sort of various personality attributes of a person, for example. I have bolded on this slide for you commercial and identity, those two words, because they're the very important sort of root touchstones of right of publicity law. And the guard, of course, is against commercial uses. And that line then between what is a commercial use or what is a news, art, fair use type use, for example, is not always clear. We've already talked about a couple cases that fall on the other side of the line. This line in the modern world is becoming increasingly blurred because of the nature of how commerce exists in terms of the use of social media and internet websites to promote brands and people and ideas without even charging money because they're able to secure ad revenue from traffic, for example. And it makes this commercial, non-commercial line much blurrier than it used to be in prior decades. What's important to know here is that there's actually no uniform federal intellectual property right at play here. Each jurisdiction does it differently. And so there's been a lot of talk, at least within the realm of intellectual property lawyers like myself, of the need to have a federal uniform standard that puts these cases in federal court potentially also, but also creates a very uniform standard and set of remedies and rights to avoid the massive differences that can exist in jurisdiction. And the differences can be significant, both in terms of the scope of the right, the scope of defenses in terms of the use, the types of remedies that are available, from damages to enhanced damages to attorney's fees to punitive damages. It varies state by state, and this then incents a whole variety, obviously, of litigation tactics in terms of where one may or could go for suit. And so the real important point to recognize here is that if you're involved with a right of publicity issue, you need to have a very clear understanding of what jurisdiction you're in and what set of law you're dealing with. Let's get to the next question. The celebrity's right of publicity, what is it about at root? Well, it's there to vindicate, as we said, a celebrity plaintiff's commercial rights in the use of their name or image or likeness or persona. The contra case to this, of course, is that a celebrity's concern over harm to his or her reputation, for example, really is remedied by state laws such as defamation law, the body of law dealing with defamation and slander. That really gets at reputational damage that comes. Right of publicity is focused on commercial uses for advertising purposes. And that's a distinction that's very important to keep in mind. Here we have a discussion of it from the California Supreme Court in the case of Winner versus DC Comics from 2003. And as the California Supreme Court notes, the right of publicity cannot, consistent with the First Amendment, be a right to control the celebrity's image by censoring disagreeable portrayals. Once the celebrity thrusts himself or herself forward into the limelight, the First Amendment dictates that the right to comment on, parody, lampoon, and make other expressive uses of the celebrity or the celebrity's image must be given broad scope. The necessary implication of this observation is that the right of publicity is essentially an economic right. What the right of a publicity holder possesses is not a right of censorship, but a right to prevent others from misappropriating the economic value generated by the celebrity's fame through the merchandising of the name, voice, signature, photograph, or likeness of the celebrity. That's a very important line to understand, and it's an economic right, and that's how courts interpret it and understand it, and that helps create a First Amendment balance and a right to make sure that once one decides to become a public figure, others can in fact engage in parody and other types of fair uses of that celebrity without being unfairly censored. For example, SNL skits by Alec Baldwin of Donald Trump, and that sort of parodying of him that's done is absolute fair use and not an exploitation of Donald Trump's right of publicity. Let's look at an example, however, of where a company went too far in terms of the commercial use, and that brings us to Michael Jordan, famed basketball player from the Chicago Bulls. This case will show us a situation where a company tried to flirt the line of using Michael Jordan's persona and went too far. And so what happened is Michael Jordan's inducted into the Basketball Hall of Fame. He's obviously one of the most famous basketball players ever. And a grocery store in Chicago takes out this ad, this color ad, in Sports Illustrated. And it said, "Congratulations, Michael Jordan." It salutes number 23. Obviously that, as you know, basketball fans know, that was his famous number that was identified with Michael Jordan as a player. And the ad saluted him on his many accomplishments as we honor a fellow Chicagoan who was just around the corner for so many years. And there was a little coupon down there to get money off the next time you go to the grocery store and buy food. And Michael Jordan did not like this. He said, "You went too far in terms of using kind of my name, the colors, the number, and saluting me." The whole tenor of the ad reads not so much as a, "Geez, we're really proud of you, Michael Jordan." It reads more as a Michael Jordan's being saluted by someone who he's endorsing, and he didn't like it. And so he sued. The case was originally dismissed by the trial court, finding that this was a fair use and it didn't, infringe upon Michael Jordan's right of publicity. The Seventh Circuit, however, reversed and said, nope, a jury, there were fact questions, it said. A jury could look at this and conclude that ad was commercial. It wasn't just a kudos to you, Mike ad. It was actually commercial to try to sell product for the company, again, because of the blurring modern lines of commerce that we spoke about earlier. And the court said it's up for a jury to decide. So the case was then set for a jury trial. It did not settle, and at trial, Michael Jordan's expert got on the stand and testified that the fair market value of Michael Jordan's identity is around $10 million per business deal. And essentially what the expert testified, is that Michael Jordan's a big deal and there's big money attached to him, and he doesn't do business with anyone unless it's worth really about $10 million. Otherwise, he's not going to put his name to it. He's just in a playing field that the rest of us aren't in. And the jury ultimately agreed, basically, and gave $8.9 million, essentially what the expert had pegged the value at, and hit the defendant with a $9 million verdict. So that's an example of how, if you're representing just some small business in a little locale it thinks it's going to do something and get cute and get close to the line and try to trade off of a famous celebrity who may have some relation somehow to the business, either by living in the same city or by having shopped there, tell your client to be careful and remind them of the Michael Jordan $10 million disaster case. That's commerce. The next slide brings us to our discussion of the other bolded word I showed you, and that is identity. And the first case we're going to talk about involves using a celebrity's likeness. And this is a case where Johnny and Edgar Winter brothers, they're two celebrity musicians, sued DC Comics because they didn't like a DC Comics that had been made that they felt was riffing off of their persona and their likeness. And this case really gets at where the First Amendment, again, trumps the celebrity's right to control his likeness. And it's that sort of commerce line versus fair use in terms of creating an artistic, creative work. So here's what happened. DC Comics issues a comic called Autumns of Our Discontent. And it's got two brothers in it. The brothers are Johnny and Edgar Autumn. So using the first names, Johnny and Edgar, but not the last name Winter. Johnny and Edgar Autumn are depicted as villainous, half-worm, half-human offspring born from the rape of their mother by a supernatural worm that had escaped from a hole in the ground. And at the end of volume 5 of this comic, Jonah Hex and his companions end up shooting and killing the Autumn brothers in an underground gun battle. And so this sort of Jonah Hex comic book episode, featured prominently these half-worm, half-human, villainous bad people. And there you see on the cover of the volume, one of the Autumn brother characters is depicted with a pale, long face and long white hair. And this was an entire universe of fiction created. Well, as you see on our next slide, Johnny and Edgar Winter, there's a photograph of them. They sued, saying, "We are well-known, famous performing and recording musicians." They picked the name Johnny and Edgar Autumn to signal readers that this was really about a riff of the Winter brothers being portrayed. The half-worm villainous characters had the same kind of, long faces, pale hair, even hats in some of the pictures like the Winter brothers wore on stage, and even similar albino features that the Winter brothers possess in real life. And so they claimed that this character and these characters were a riff on them, and it was an infringement of their right of publicity to control the commercial exploitation of their likeness. DC Comics, of course, defended, saying, absolutely not. We're not selling a product using your brand. We've got a fictional comic that's got a whole universe of events and information and people and characters occurring, and these two characters are there. And yes, to some extent they may have been inspired by you, but we have the right to do that in terms of parody, fair use, social commentary, and ultimately the First Amendment. And so as you see on our next slide, the California Supreme Court, had to balance these competing issues. The court said, depictions of celebrities amounting to little more than the appropriation of the celebrity's economic value are not protected expression under the First Amendment. And so in other words, if you had simply taken a picture of those celebrities and put that on shampoo, for example, or hats, because they like to wear hats, that would be a pure economic appropriation, and that's the heartland of the right of publicity. But, as the Supreme Court said, on the other hand, when a work contains significant transformative elements, it's not only especially worthy of First Amendment protection, but it's also less likely to interfere with the economic interests protected by the right of publicity. Pause here. In other words, what the court is saying, you can continue to exploit your economic rights that exist in the right of publicity because this is not a competitive substitute threat to them. If companies want to pay you for endorsements or have you associated with them for your brand, this doesn't interfere with that at all because this is not an abuse of your economic right. What the court is saying as it goes on is that works of parody, therefore, or other distortions of the celebrity figure are not, from the celebrity fan's viewpoint, good substitutes for conventional depictions of the celebrity. And therefore, these types of transformative uses don't generally threaten markets for celebrity memorabilia or endorsement that the right of publicity is designed to protect. That is that central fault line between the two. And so the test the court adopted is really this inquiry is whether the celebrity likeness being used by the defendant is one of the, quote, raw materials from which an original work is synthesized, or whether the depiction or imitation of the celebrity is the very sum and substance of the work in question. We ask, in other words, whether a product containing a celebrity's likeness is so transformed that it has become primarily the defendant's own expression rather than the celebrity's likeness. And of course, applying that test as applied to the comic book, the Supreme Court held for the defendant DC Comics. Now, let's go to another case involving identity, and this is the famous Bette Midler voice case. This is a case that comes out the other way in terms of this one protecting the celebrity. Here's what happened in this case, and it's reported at 849 F. 2nd 460. It's from the Ninth Circuit in 1988. Ford started an ad campaign for its cars, its Lincoln Mercury Ford cars. And the whole ad campaign is built around the idea of inspiring nostalgic sentiments from, the good years of the 60s or 70s by using famous songs from that era sung by the original artists. And so Ford would go to the original artists of some 1960s or 70s songs, ask them to sing the song, and if they agreed, they would sing the song and they'd use it. But if the artists didn't agree, Ford would just go find a voice impersonator to sing the same song and have it sound like the original artist. And so Ford went to Bette Midler and asked, hey, will you sing your famous 1970s song, Do You Want to Dance? Bette Midler said, no, I won't do it. Ford said, cool, that's fine with us. And they went and hired an impersonator. The impersonator sang her song, Ford issued its commercial. Bette Midler was not happy. She sued Ford. Ford, again in the trial court, gets a summary judgment. Bette Midler's case gets dismissed. And here you can hear, and we're going to play for you right now, the 30-second commercial from YouTube, which you can watch and hear, of Ford and its commercial with Bette Midler's song. So go ahead and listen for the next 30 seconds.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road. Introducing Sable. Mercury, the shape you want to be in.
So, you've heard the song now, and as you can see, or hear, that sounded just like Bette Midler. This case went up to the Ninth Circuit, and the Ninth Circuit was not amused. The Ninth Circuit said, a voice is as distinctive and personal as a face. So the voice, that is, a voice is protected by the right of publicity. Quote, the human voice is one of the most palpable ways identity is manifested. And it sent the case back to go to the jury. This case, like the Michael Jordan case, did not settle, and Bette Midler got $400,000 for singing a song, basically. Pretty good deal. The next case of identity is the famous Cheers case, and it's Norm and Cliff, our two favorite characters, as you remember, from the Cheers bar. And this is an example, and it's really our final example, of where copyright and the right of publicity simply collide for celebrities. And so here's what happened. Actors George Wendt and John Ratzenberger, Norman Cliff, they brought an action against the creator of an animatronic robot of them that were being based on their likenesses, they alleged, and were placed in airport bars that were modeled upon the set from Cheers. And so what's basically going on is a company says, hey, we can go create bars that look like Cheers, put them in airports, and have these animatronic robots of Norman Cliff sitting at the bar. Patrons will come in and order a beer, and it's evoking Norman Cliff at the Cheers bar, and it's all fun and great, right? And Norm and Cliff, the actors, weren't so thrilled. They filed a suit claiming that use of our likeness violates our right of publicity. That's me as a person, George Wendt, me as a person, John Ratzenberger, whose identity you're using in the bar, and that infringes on our right of publicity. And there you can see some photographs of the animatronic robots that were created. And what the court held, this is the Ninth Circuit, is that a reasonable jury could indeed find these robots to be sufficiently like the impellents, that is, evoking their persona, that the use was an unlawful taking. Now, this creates a potential massive collision with copyright laws, because in the Ninth Circuit then, there was a massive dissent by several judges who said, hold on, Paramount had licensed the rights to the Cheers bar and to the characters Norm and Cliff that were owned by Paramount. Those characters are creations, of course, fictional creations that belong to the copyright owner, Paramount ultimately. They had licensed this IP to have this bar developed by the company developing it, and that was their copyright to license. And so the Ninth Circuit dissent from en banc rehearing to this basically posited the idea that when an actor, a person, a celebrity, portrays a character, it's impossible to recreate that character without also evoking the underlying image of the actor, the human being, in the minds of the viewers. And what this creates then is the problem that Copyright holders have the rights to the character, and they should be able to use that character and create derivative works of that character however they see fit. And that means Paramount should have the right to reproduce the characteristics that bring Norm and Cliff to mind. And the question posed by the Ninth Circuit in this dissent was, could Paramount cast Shelley Long in the new Brady Bunch movie without creating a tribal issue of fact as to whether she's really treading on Florence Henderson's right of publicity? That's one example, right? This shows the collision between copyright law in terms of characters and right of publicity law, which protects those people who portray those characters, and how the two ultimately merge, really, in this case, where you have this right of publicity and copyright set of issues that have simply merged and created this intertwined set of DNA strands, basically. The issue remains unresolved because the United States Supreme Court refused to grant cert, and so as a result, as it currently stands, you cannot make a bar using Norm and Cliff without getting the rights from George and John. So, our conclusions for today's presentation from the Curious Lawyer on celebrity and paparazzi law is that the copyright for photos belongs to the photographer. That's the author, and that's who owns the copyright. Celebrities can be approached and photographed in public, but if you go too far and harass them, state harassment laws will not be stopped by the First Amendment. The public is open for photo and news gathering purposes, of course, but remember the Onassis case, which is just an example of going too far. The other conclusion we have to keep in mind is that various states have zoom law lenses, and it's very important to be careful and not fall into the trap of thinking that just because you're on public property that you can zoom into private property. Those laws can lead to real liability. There are, of course, limits on those laws in terms of legitimate transformative or art, news, informational gathering, education type purposes, as we saw in some cases. And on the celebrity side, shifting from paparazzi, we saw that they really have the absolute right to control their name, likeness, and image. And this can even collide with some basic, assumed copyright principles at times. And so what this ultimately means is that outcomes will vary by jurisdiction because it's state by state for right of publicity. But the damages awards, as we saw, can be staggeringly high. So given the celebrity capacity to monetize their brand, which is even greater in the internet era than ever before in terms of the endorsement and brand value of celebrities, companies, your clients, need to be very careful treading over those lines. And we end by remembering Norm and Cliff. Have a great day, have a beer, but be careful using their characters if you have clients who want to run out and do something like that. I really hope you've enjoyed today's presentation of celebrity and paparazzi law. It's a curious world out there for you, the lawyer, and stay tuned for other programs we present on arcane, fun, interesting, and whimsical legal topics through the Curious Lawyer. Thank you. All right?
Perfect.